everyone. Namaste. Good evening where it's evening and good morning where it's morning. Uh, here, I'm going to share my screen and talk for a few minutes about IP and e-commerce. Let's see if I can do this right. I think so. Can everybody see my screen?
Yes, sir, we can see.
All right, so my topic is about IP and e-commerce and domain names. I was initially going to speak on the topic of just IP and e-commerce, but that's such a broad topic, I thought I'd narrow it down for the short time that I have to speak, which is more than enough time, but you know, each area is so broad. You can see right here that e-commerce, as many of you already probably know, is at the center of spokes that reach out to a variety of different areas. So as is my want, being from my academic side, we'll talk basically about some general characteristics and then narrow it down to specifics. And I also want to make sure that we're all starting from at least a shared understanding at the outset. So let me see here, trying to move my, there we are. So what is e-commerce to most people? You know, that's business to consumers and business to business interactions utilizing the World Wide Web, the internet. So we have transactions both between individuals as well as internal transactions that are going on within businesses to support the activities amongst the consumers, the private business, and the government. And so those who want to engage in e-commerce have to adopt a business model that allows for the buying and selling and the regulation of internet commercial activity. So this brings about certain concerns. We call these the top concerns amongst e-tailers when we're talking about e-commerce and people thinking about going into business these days. Of course, it's more of a clicks over bricks, as we say here, where people find it obviously much cheaper to invest in starting up business on the internet and driving traffic to their businesses there than going out and buying property and building up a physical structure. So e-tail, as opposed to a retail, is a big business now, and e-commerce has several concerns that we hear about on a regular basis. Number one being cybersecurity. I know in nations across the world, it's often a news story where you wake up and you hear that somebody has hacked into customer files or corporate files and found out customer information on credit cards and where they live and things of that nature. And so this becomes an issue that has to be addressed when you're thinking of establishing a website and doing e-commerce business, how to protect the information of the business itself, of the governmental entity, and certainly of those individuals who interact with those entities. We have competition, much like in real space. In cyberspace, there is the need to address what is fair competition as opposed to unfair competition. And that is much more difficult when you're dealing with a global enterprise that touches every corner of the earth. We don't have global regulation in terms of laws. So how do we do that in terms of our e-commerce space? And then on a more particularized basis, fulfilling orders of customers, as well as uh, fulfilling orders if they are orders from governmental entities. Again, that exchange of information. For those who are already engaged, some of you might have e-commerce sites already. Some might be thinking of going into it. Right now, the average conversion rate, meaning how many sales somebody gets versus visitors, is less than 3%. So you want to get a lot of visitors, and you want those visitors to be high quality when they're coming to your e-commerce sites. And you know that you do that through optimizing search engine recovery and retrieval. So you want to make sure that when people are putting in search information, that the returns on those search information, those search engines sends those people to your domain name, your website being where your domain name resolves to. So all of these things are important at the outset: the design, the functionality, what is your marketing plan, what's your digital plan, how are those things going to be addressed as you sit back and think about either establishing e-commerce as a business, or from a lawyer standpoint, what we think about when we're advising individuals who are either establishing e-commerce connections or have disputes involving e-commerce. Now, all of those things have some intellectual property component attached to them. And just to be sure we all understand, a simple reference point for intellectual property is that it normally involves 3 general areas. Those areas you've heard in introductions to some of the individuals on the panel today. Some of them are quite skilled and experienced with patents. And what is a patent? A patent is something that deals with a new invention. And inventions come in all ways, shapes, and forms. We'll talk about how they relate to e-commerce momentarily. But it's an invention, a thing, something that has utilitarian aspects to it. Copyrights, on the other hand, deal with how things are expressed, how they look, how they sound. Are they artistic? Are they creative? Trademarks are identifiers. They deal with identification. So, when we talk about a patent, invention, copyright, expression, trademark, identification, and trademark law also deals with whether the competition is acting fairly or not. And so we look not only at the trademark, the item, if it has a trademark on it, but also what it looks like, the trade dress, what constitutes the thing that we are trying to identify. Is it a trade secret? And also maybe a trade name. And you can see here, we have a TM in a circle, which indicates trademark. It means that the producer of whatever you see that mark or that symbol on is claiming that they have some rights in it that are exclusive to them, so that other people won't take the same mark and use it on the same or similar product and cause some confusion. The C in the circle is recognized generally across the globe as an indicator that someone claims copyright protection on their particular expression. And these things are regulated in different countries by different entities. You see the insignia here of the United States Patent and Trademark Office, which deals with trademarks. We have a separate office, the Library of Congress, that deals with copyrights. And you have the Intellectual Property Office of India insignia here, which many of you, if not all of you, are quite familiar with. So when we talk about IP and e-commerce, I mentioned that each of the main IP areas have some interaction with e-commerce. And each of the IP areas, even though I've given you a general reference point, they have subsections as well. So patents may involve the mechanics of how both software and hardware work, but it also may involve the process or the modes of communication between sites. Copyrights might involve what the site looks like, but it also might involve the code, the source code, or other types of code that instructs the site to go through different processes. And on a more specific basis, again, you have choices in some of these. This is where the advice comes in the research when you're starting out dealing with intellectual property as it relates to e-commerce. Do you want to set your site up with code and software that is protected by copyright, or do you want to use a patent? Most places, such as the US, it's costs less than $100 to get copyright protection, including registered protection from the government, where somebody who is trying to do software protection through the patent system may have a general wait of about 2 years and expect to spend $15,000 to $20,000 just to get it through the process. So is it worth it? That's something that depends on the specifics of the subject matter being sought to be patented. As I said, copyrights deal with expressions. So what does the website look like? What type of text is used? Graphics, audio, video, all of those things go into successful websites, e-commerce websites. That's what's going to drive people to return and also drive the curious to make some initial site visits, is how attractive the site is. In some countries, there's express database protection law that can protect the information that's collected on the website and used to interact with the customers, or if it's a governmental website that's collecting information, they put together databases. Some countries have database protection. Some regions have them, such as there's express database protection in the European Union, where each country has the ability to effectuate whatever laws are necessary. There's not a uniform law, but there is a directive that they all have to have a database protection law, as opposed to the US, where we do not have express database protection law. We feel like we can squeeze database protection in maybe the copyright law, or maybe we think it's not worthy of protection at all. Trademarks, there can be names, symbols, signs. Many people have different types of graphical representations of their alphabet. As you know, when you look at, say, the phonetic alphabet here versus, say, a Hindi alphabet, or alphabets in Middle Eastern countries or other Asian languages. So all of those things come into play when we're talking about copyrights, and especially trademark, which indicate the source of a product. Another thing that a number of countries have is industrial design. That's something that the US doesn't have as well, a specific statute for that. But again, when you're thinking of designing an e-commerce site, you want to know what the broadest scope of protection is that can be secured, and you want that for your particular client, and you want that for the success of the business. And then patents. Patents are used for e-commerce systems, search engines, technical tools, because they're more utilitarian in nature. When you see the R in the circle, that indicates there's a registered trademark. That means that there's been a governmental entity that has protected the trademark involved, as opposed to a lot of people think that a P in the circle means that there's indicates a registered patent. That's not true. Patents are usually indicated as registered by long term, something like registered patent, and you have the number for that patent. P in the circle is usually just indicative of a different way of showing copyrights, which is a phono record or a phonograph type of copyright. And here's an example of a patent, one that deals with e-commerce, facilitating electronic commerce through automated database reputation characterization. You can look at this, and many of you may have already done some research on e-commerce patents. But again, you know, dealing with patents that cover subject matter, whether the thing sought to be patented is even patentable subject matter, and the different elements needed for a patent, that's a much longer presentation in and of itself. That's much more directed toward that area of intellectual property law. So, it looks like my sharing thing got a little bit off base here. Sorry about that. Let me see, where am I? Oh.
Sir, you can stop it and once again you can share.
Okay, I'm trying to, okay, here we go. All right, sorry. All right. Okay, so I think we can see the broad scope of IP options as far as e-commerce is concerned. Now, trademark law, though, is key because it all starts with the website. People won't know what your e-commerce is. There won't be that business to business, government to business, government consumer interaction unless they get to the website. And the website, you know, it certainly is an embodiment of brand planning, marketing, advertising, all of these things that we think about that go into product development, and goods or services are protected under trademark law. All of those things are labeled. And so we know what trademarks deal with. And trademarks oversight on the internet is something that is very difficult to police. The first trademark issues were thought to be dealt with simply through your basic trademark law and going to court. The first domain name was issued in 1985 as symbolics.com. And since then, there have been more than 366 million domain names that are been activated. As a matter of fact, there have probably been 10 times that many, but there are currently more than 366 million active domain names. And when there's a conflict between a domain name and a trademark, then that's resolved through what's known as the Uniform Domain Name Dispute Resolution process. And everybody who registers a domain name agrees to go through this process, although most don't know about it. The first domain name proceeding occurred in 1999, which was a dispute between the World Wrestling Federation and the World Wildlife Fund. So the Wildlife Fund, known as WWF, like the Wrestling Foundation, they were both making a claim to WWF. Since that time, there have been more than 70,000 cases decided by arbitration. But I'd say here, you know, keep the scale in mind. 1985 to the present, that's a little over 35 years. We've gone from one domain name to currently active 366 million. We've gone from one case in 1999 to a little over 20 years later to only 70,000 cases being decided. So, is that a red flag, something that we have to address? Or does it show a certain degree of futility when we're talking about trying to maintain some trademarks related oversight to domain names as they are used on the internet? Here's some current figures as where we were at the end of 2020 as far as domain names are concerned. Some popular domain names, at least for the top level domain, and we'll break down what consists of a domain name soon, but .com, everybody is probably familiar with that. .cn, .tk, these are country code domain names for places like China, Russia, the UK, .net, .org. Those are also popular. And this just shows how many users there were at the end of 2020 for those particular, what we call generic top level domains or country code top level domains. Put this in here, you can see that among some of the other domain names that are frequently used, .in is up there, 18% increase over the last few years with about 2.9 million users right now. And that's significant in a way because in India, as you may know, if you've already procured domain names or may have tried to use the .in country code, there is an authority that deals solely with the .in country code in India. But let's look at what we're talking about as far as domain names for those of you who might not be familiar, though I know I see a lot of younger people in the crowd, much younger than I am. And so you grew up with this type of stuff and are probably much more aware. But the language that we use for domain names are uniform resource locators. And that is your address on the web. We talked about search engine optimizing and driving traffic to the website so that your commerce visitors might in fact want to do transactions with whoever the owner of that website is. So you have to get there. And each site on the web has its own address. You've heard of it as the information highway. If you're on the highway, you need to know where to get off to get to where you want to go. This is your domain name that tells you that. So you have protocols that tell you how to retrieve the information, subdomains, and then you have the main domain name, which is the thing that is selected by an individual who wants to have an e-commerce site. The totality of all of these parts is known as the root domain, and it is something that is monitored and the domain names issued by an organization known as the Internet Assigned Names and Numbers, the Internet Assigned Numbers Authority, which is IANA. And you might have seen this symbol before. This is the International Corporation for Assigned Names and Numbers. They work with the IANA. In fact, the IANA is a sub part of that organization, but this is where all of the domain names are actually issued. So we've all seen this, and there's a domain name associated with this program today. And wherever you go on the internet, how you get there, the type of subdomain, and then the top level domain is the .gov, .com. It can be the .in, .net, and so forth. But the meat of it is the domain name that's selected. And that selection may be a registered trademark, or it may not. That is something that the selector wants to be as distinct as possible. And sometimes they want it to be a trademark or as close to a trademark as possible. The difference between trademarks and domain names is that domain names are specific. You can only have one address. So it's specific to that address on the web, and it applies to anything that resolves to that address on the web, as far as goods, services, any types of presentations, expressions on the screen, and so forth. And a domain name can be gotten pretty cheaply. I know you may see them pop up from time to time, sales on domain names. I don't know if any of you have bought any. In a sense, sometimes it's like playing the lotto. If you can get a generic domain name, you might be able to resell it for a lot of money. They sell domain names in the US for as cheap as $1. The highest resold domain name, I believe cars.com or insurance.com, was for $43 million. So if you can get a hold of that, that's great. Now there's been a lot of move toward using robots to find domain names for individuals. Trademarks take a little more time, a little more money, and they can be acquired simply by use in some places, but they have limited geographic enforceability, and they have judicial oversight, which is good, as opposed to domain names which have administrative oversight. Let me see here. As I mentioned, everybody who gets a domain name agrees to go through an arbitration process. It's cheaper. It's not binding, but most individuals would go through that process with a maximum. A sole individual can handle for, in the US, what amounts to less than $5,000, as opposed to trademark litigation, which could cost nearly $1 million. So if the parties aren't in agreement with the resolution to an arbitration, they can appeal that to court where they registered the domain name, but appealing arbitration decision is quite expensive. Arbitrations are handled through a number of different arbitration centers, and I have those listed here as well. I believe I'm all about out of time, so I just want to click through a couple of other things and point out here again the pros and cons of going through domain name arbitration. You can, of course, go to court if you'd like to, but you don't have to go to court. You are mandated to go through the arbitration procedure, but an e-commerce person doesn't have to actively participate. They can just let the arbitrators decide whatever they want and deal with it in that fashion. Let me see if I'm out of time here. Let me see. Not quite. So let me just go through the rest, if I can, pretty quickly. You can also register a domain name as a trademark in some particular jurisdictions, such as the US. To do that, the domain name has to go through the same qualifications as a trademark does. And there have been some landmark cases. The very first case involving a domain name that was decided by a court in India occurred in 1998. And if you look at landmark cases in India, you'll find that most of those listed are court cases. The same with the US. In the US, there was a $33 million verdict in a domain name case, but that happened in court. And one of the more notable, because of recent events, involved our former president, Donald Trump, who has more than 3,000 domain names himself. He was concerned about somebody honing in and registering Trump India and Trump Mumbai. He actually won that case. I mentioned that there are domain name disputes filed for the .in case, and here's just some example of the numbers of those cases in recent years. And then finally, some criticisms that have been voiced over the UDRP proceeding. But it is the only global proceeding for dealing with e-commerce related matters. If you have a patent dispute, it's going to go to a patent court, and that court's going to be located in a particular jurisdiction where individuals had to invest. There's no global patent that somebody gets. There's no global copyright that somebody gets. And there's no global trademark. But when you get a domain name, it is global. And we do have a resolution process for dealing with that. I go back though to the earlier comment, how effective is it when we look at social media, for instance, we know that there are literally billions of social media sites now, and each site has to have a domain name. We are moving slowly if we compare the growth in arbitrating disputes with this. Maybe we need a whole new different way of approaching it. But nonetheless, for e-commerce, if you're going to start a site and be effective in e-commerce, it starts with your website, and you can't have a website without a domain name. And you have to think about trademark issues when you're dealing with selecting the right domain name. So I'll stop it there. Thank you for the invitation and the attention.
Thank you very much, sir, for your insightful theme address. Now, I request our second theme speaker, Dr. Natalie Steinoff, Professor and Director, Intellectual Property Program, Faculty of Law, University of Technology, Sydney, Australia, to enlighten us on the topic of incentives for the commercialization of intellectual property rights. Over to you, madam.
Thank you very much. And a very interesting talk, Professor Wilson. It was enlightening to hear all the different issues that need to be considered in e-commerce and particularly in domain name law. I'm going to be taking you to a totally different area at the present point in time and talk about incentives in relation to intellectual property and its commercialization. I'm going to share my screen with you. Hopefully this will work. Can everyone see my PowerPoint there? Yes, oh good, excellent.
Yes, ma'am.
Thank you. So this is an area of particular interest of mine. I happen to have written a book about this area with my colleagues at two different institutions. And I think it's an important issue to think about from the point of view of, well, once you've got your intellectual property, what on earth are you going to do with it? And quite often people don't really think very strategically in the process of what they're going to actually do with their intellectual property and how best to make use of it, given that they have more often than not a very time-limited monopoly to in fact make a profit out of all the time and expenditure they've spent in developing their invention or their other forms of creativity, which come under copyright law, inventions under patent law, et cetera, So I thought I'd start off with, first of all, talking about the fact that intellectual property is yet another economic instrument, just like taxation system is an economic instrument. And from the perspective of what it does as an economic instrument, we all know that intellectual property effectively has the role of incentivizing creativity and invention. It provides an opportunity for those who have got genius and interest in creating things to find a way to be rewarded for that and to be rewarded for providing, I suppose, an increase in the world's knowledge, in the world's access to technology, in the world's access to different forms of creativity, arts, etc. And the mechanism of intellectual property is one which provides an opportunity for greater access by society to these things, and at the same time a reward to those who've created it, and an opportunity to actually encourage further creativity and invention. So from that point of view, intellectual property itself is a form of incentive to increase the technological welfare of society, the creativity welfare of society, and the opportunity, I suppose, to encourage new technologies and new forms of development over time. And the problem with that, of course, is that it is a form of monopoly right more than anything else. And that means that it can also create some problems in the marketplace. But we're not going to be concerned about those particular issues at this point in time. That's one of the negative issues that people tend to put towards intellectual property rights. What I'm concerned about in this evening's presentation is how do we encourage the commercialization of that intellectual property once it's been obtained. And so we need to think about different mechanisms that achieve that. And one of those mechanisms is, in fact, through the taxation system. Taxation systems are not just there for the raising of revenue, for funding government activities. We know that's the key reason for it. But more often than not, they have actually been utilised in a variety of other ways and to achieve different ends, such as different social, economic and political purposes, to influence society, to change the way we think about things, to change social behaviour, and to overall provide some benefits to society as a whole. And one of those is the example of utilising what they call tax expenditures, and tax expenditures are where the government decides to make use of the funds that they have received from collecting revenue, from collecting taxes from society, and then utilising those funds to encourage particular activities. So it could be achieved by giving particular tax breaks to an industry. It could be achieved by giving tax breaks to a particular activity as a means of trying to encourage more of that activity or encourage a growth in that particular sector of industry. And that is exactly what has been utilised by many countries around the world in the search for trying to actually find mechanisms to commercialise intellectual property rights. And I'm going to be using, of course, Australia as an example of how we have done things. So excuse me for focusing on that. But taxation is very much a jurisdiction-based field of law, and much like intellectual property, but perhaps taxation hasn't been as globalized in the same sense that intellectual property rights have been globalized. Although we are seeing a movement towards that more so in recent times. The way I like to start a discussion about the use of taxation in the intellectual property commercialization space is to first identify that there is an actual life cycle around intellectual property. So what I mean by that is that there are effectively 3 stages to an intellectual property right and its use and its end. So starting off with the whole process of actually creating and developing intellectual property rights raises questions about expenditure in doing so, how to classify that expenditure, whether it's what they call on revenue account or whether it's what they call on capital account. And more often than not, a lot of the tax incentives that have occurred over time in relation to intellectual property has been at this stage, at the stage of the creation and development of intellectual property rights. So we'll see that there's a focus on that particular aspect. The second stage is once we've managed to generate intellectual property rights, what do we do with it? Well, we have the potential to either make use of that intellectual property as the creator of it and create forms of products and services utilizing that intellectual property, which then will result in a business of some sort producing a profit at the end. The other alternative to think about is where those who are holders of these intellectual property rights don't actually do the work themselves or don't actually commercialize the intellectual property themselves, but license others to do so. So there might be inventors of interesting gadgets or chemicals or pharmaceuticals or machines, but they haven't got the actual capital investment or size to be able to manufacture them at a level which is necessary to be able to actually monetize the intellectual property. And so they might actually license that technology to a manufacturing company that actually does have that capability. And in that process, that what is achieved is effectively an income stream from the licensing of that intellectual property right to the manufacturing company that is able to then make use of the intellectual property, create the products and sell them in the marketplace. Now, the difficulties that occur, of course, is that these things can often be cross-border. So you can have an inventor in one country needing to actually engage manufacturers in another country to actually produce those products and then sell them in the marketplace locally and globally. And in those circumstances, you have issues surrounding how taxation takes place in relation to that income. And so when you see that there is income that it's needing to cross borders, so for example, with the royalty, if you have, for example, a person in Australia is the inventor, effectively licensing a manufacturer in, say, for example, Thailand, the royalties that would come back from the use of that intellectual property through that licensing would therefore be taxed potentially in two locations. So there'd be a withholding tax in Thailand potentially, and then of course, ultimately an income tax in Australia. And of course, the reverse could be the case. And that requires a knowledge of whether in fact those two countries have a double tax treaty between them. And those double tax treaties try to deal with the fact that income might come from one source, but the taxing ability is based on residency. In other words, where is the party that is receiving the income actually physically located, and what is the tax ruling for that particular nation? Do they tax basically on the fact that it's a national that is receiving the income, or do they tax on the fact that where that income is coming from? And so there are actual treaties between nations that try to deal with those issues. Then there's another aspect that needs to be thought about when it comes to income that's generated from the use of intellectual property, and that is what they refer to as transfer pricing. And transfer pricing is a situation where multinational corporations will make use of the differing tax rates between countries, whereby you might have a higher income tax rate country that is perhaps manufacturing and a lower income tax country that is doing the selling. And by shifting the products from one place to the other and increasing expenses in a high tax country and reducing and increasing the sales in a low tax country, you're actually depriving the country that has manufactured and expended at the higher rate from receiving an adequate profit from that arrangement. It's a little bit more complicated than the way I've explained it just then, but it is effectively making use of tax havens to reduce the overall income tax of the multinational corporation. But unfortunately, that's often done at the expense of the nation that perhaps has had the greater expenditure take place there, and is losing out on a flow of income taxes that would then, of course, assist the government in that instance to supply the services that it would normally supply to its society. The GST is what we call the goods and services tax. Other countries call them VAT, value added taxes. Those are things that we also have to consider when it comes to selling of services and goods, and whether there are cross-border adjustments or not. The third stage is the disposal stage of the intellectual property, and you can look at it from 2 points of view. From the point of view of where the intellectual property has a fixed life and it comes to an end, to the circumstance where it's actually a sale of the intellectual property through an assignment to a purchaser of the business, for example, or just simply to another business that is willing to purchase the intellectual property. So they could be buying the trademarks, and trademarks, of course, can continue on in perpetuity so long as you keep on paying your renewal fees and no one else tries to have you expunged from the register. But it could be a patent, or it could be a design registration. Those are fixed lives of, in Australia, that's 10 years for a design registration or 20 years for a patent. And if you're coming close to the end of those, then there's the question of you're basically having a depreciating asset as you're working along the way. So what are the things that people need to consider when it comes to commercialization in particular? The first important, well, I suppose the most important thing is, how do you actually structure your business? So in structuring your business where you're a creator of intellectual property, raises in itself tax implications. So whether you start off as a sole trader or in partnership, there'll be one way of being taxed in those circumstances compared to if, for example, you're in a joint venture arrangement between two corporate organizations, whether it's the creation of a corporate entity as the joint venture, or whether it's a pure contractual arrangement. And we tend to see pure contractual joint ventures mostly in the mining industry, to be honest. Where you see multiple mining companies coming together to actually work a particular site. And the interesting thing is that in the sale of the produce of a mine, referred to as royalties as well in those circumstances. Then the other thing to consider is, if you form a company, what are the circumstances in terms of the tax implications there? And then finally, if you're in a common law-based nation, like we are talking about all three countries here, there's a trust arrangement that could be put into place to operate a business and provide benefits to the beneficiaries of those trusts. And in each of those instances, we have to consider what the tax implications are to then best understand the best way to actually go forward in a commercialization sense, once you've got that intellectual property. So, for example, we need to think about the expenses that are being incurred in the process of creating intellectual property. Now, I've given you some examples here of, under Australian law, the Income Tax Assessment Act. I mean, you don't need to obviously know that, but you can compare it to your own legislation in India. When it comes to the question of the expenditure, you have opportunities. Usually there's a general type of deduction which relates to how the general expenses that a business would incur in the process of producing intellectual property, whether it's a film or whether it's a publication, a book, a newspaper, whether it's an invention of a pharmaceutical, where it's the invention of a machinery of some sort, whether it's software. And so we need to think about those types of expenditures and be able to consider whether, in fact, what we're producing, what we're actually expending is something which is considered what they call a general deduction, or whether, in fact, it is something which is counted as capital in the end. And with capital, the difference is that, yes, you've spent a lot of money. If it's a capital classification, you may not be able to actually claim a deduction in that particular income year. But what you will be able to do is determine what the life of that capital item is, and then divide it up according to those number of years and obtain what they refer to as a capital allowance or a depreciation amount, and claim that from the income each year. Now, part and parcel of that process has then led to opportunities for governments to then consider special concessions and incentives in this space. And the reason why I raise that is because, as I said, the capital allowances will take into account the life of that capital item and divide it up over that period of time before you can actually finally have a full deduction for that item. So it really relies on how long the capital item is going to be useful to the business. Where the special concessions and incentives can come in place is that they can take a look at that and say, look, we're going to be incentivizing the film industry or the TV industry. We're going to be incentivizing special areas of research and development. It could be green technologies. It could be the production of vaccines, as we know today. It could be in a number of different fields. And by doing so, they're going to actually say, well, we're going to take some of these capital expenses and allow you to claim them in your tax earlier than you normally would be. So the benefit to the business is, in fact, that you're getting a larger deduction earlier on than you would if you were in a normal circumstance with an ordinary business. And so this is how governments will find ways to incentivize particular industries. They will choose industries or particular activities that they really want to encourage business to get involved in. And they will find those sorts of examples where they can actually provide a positive result for that particular industry in being able to bring forward its expenses and claim it against its current income and thereby reduce overall its taxable income to the government. The other point that I've mentioned there is tax consolidations, looking at the whole question of where you have multiple companies in a corporate group, and you have examples of where there's acquisition of intellectual property assets across the group, and then the utilisation of those assets amongst the different companies within the group, and the ways in which those mechanisms can be also utilised to provide a benefit to the overall operations of those businesses. So as I mentioned, in the process of the creation of intellectual property, you have the general deduction, as I mentioned before, which refers to any loss or outgoing that you would be incurring in the production of that accessible income. And noting, of course, that anything which is of capital nature generally won't be deductible outright, except through, for example, the mechanism of depreciating assets, or what they call capital allowances in other jurisdictions. And that case law there under some newspapers was trying to explain the different tests for trying to determine what in fact you have when you've been engaged in that business. So we have in particular also a whole division in our tax legislation which talks about these uniform capital allowances and looks at the whole range of different types of examples where in fact the tax office has provided these particular types of incentives. And it looks at questions about how that capital asset can decline in value. And so here we would be looking at, from the intellectual property point of view, once you've established certain types of intellectual property, they can actually be treated as depreciable assets. Now, the types of intellectual property that are more likely to be treated as depreciable assets are those that have a very fixed life. So, for example, patents and designs that I mentioned beforehand, because they have a fixed life, are perceived to be depreciating assets, which allow for, therefore, bringing forward the overall costs of creating them to be able to potentially utilise those incentives in relation to these intangible assets and their depreciation. Copyrights also, with the exclusion of films, have got a fixed life, although the fixed life is significantly longer than for patents and designs. Trademarks and other unregistered intellectual property are not perceived as being what they refer to as wasting assets, because they can continue on in perpetuity if you deal with them correctly. You are actually instead potentially increasing their value over time, as opposed to decreasing them, as you do with patents and designs and copyrights. And so you need to be thinking about the effective lives of such assets if you're going to be able to make use of the capital allowances regimes. Which brings me to the examples of the special concessions and incentives. So Australia in particular has its own film and television industry, as does India. And in order to encourage that industry, we've had a variety of different types of concessions over time. For the past 30 to 40 years, we've had changes in those concessions depending on the circumstances of the industry as it's been developing. And most recently, we have a variety of concessions which are very much targeted, and I'll mention those shortly. The other concession areas has been specifically in the research and development field, so looking specifically at various forms of technology. And that has come about, in fact, we've had different forms of research and development tax incentives and concessions since the mid-1980s, where it was perceived that, in fact, Australia has been, really behind most of its OECD partners in being an active R&D nation. Now, it's a very interesting situation because we have a lot of research that's world-class in our universities, but they haven't really translated particularly well into our industries. And so Australian industries were for a very long time very complacent and were not particularly interested in research and development. And so the government had to find mechanisms to try and encourage that sort of development. And they did so through the research and development tax incentive that started off in 1985. And it has gone through various iterations, changes up and down, as those incentives developed and created circumstances which enabled, unfortunately, groups to actually take advantage of these incentives and wrought the system rather than actually trying to improve their particular industry and actually create some positive research and development. So we've had that particular tax incentive go up and down in its availability and its structure to try and deal with these sorts of examples where the rorting element has had to be dealt with in many instances. Then more recently, we've had a national innovation and science agenda that the federal government has really focused on trying to encourage innovation and science in Australian universities and translating those into joint ventures with industry. And various incentives come about back in 2017, 2018 in the budgets then to actually do so. Australia, unlike the United States, Australia has a very poor venture capital industry and has had to have a bit of a push along with various mechanisms to try and encourage that industry. It is starting to flourish a bit more today than it has ever been before. And I think we're starting to see a lot more focus on entrepreneurship in Australia than we have ever before seen as well. Because too often what has happened with Australian research is that it ends up being either sold offshore or licensed offshore and very little commercialisation actually taking place in Australia. And so the government has seen fit to try and find mechanisms to change that. So if we look to the film and TV incentives, there are three key areas that have been identified as mechanisms for focus to incentivize the industry in these particular ways. And one of them is the producer offset for Australian expenditure in making Australian films. So encouraging producers to actually invest in making the films in Australia and providing those producers with a special offset against any income that is produced from those films. Then the other one is, even if it's not necessarily entirely produced in Australia, then certainly if the location of some filming is taking place in Australia, then there'll be an offset for the Australian production expenditure by having the film located in Australia. We've seen that actually quite useful, because that has actually resulted in a number of productions actually taking place in Australia that probably would not have taken place in Australia. And that has been a positive tax incentive from that point of view. And then we have the post-production processes, the post-digital and visual effects production in Australia. That has been also a very positive tax incentive and has enabled, you will see quite often a lot of the different digital and visual aspects in movies today have actually got an Australian component in it, with some very strong production houses located in Australia. Division 376 is basically the where you would find the provisions in the Tax Assessment Act. Now, coming to research and development tax incentive, we will see that it effectively, the incentive itself has replaced what was referred to as the tax concession. And you're looking at income years starting from the 1st of July 2011. As I mentioned beforehand, we've had a form of income tax incentive, whether it's a concession or incentive, has been around since the 1980s, but has had many different types of iterations. And they actually started off with providing very generously a tax incentive of 150% of the expenditure that was associated with research and development. The way people got into it was, first they had to get approved for making use of that particular concession, and that was achieved by a particular board of industry that would actually identify certain industries that the government was keen to encourage. And if you happen to be from that industry that was being encouraged, then you could put forward your plans of what you were proposing to do as for research and development. There had to be a level of risk associated with that. If there was no risk associated with the research and development, then you actually were not entitled to get the concession. And in so doing, it was actually quite useful for particularly some smaller organisations, smaller companies that were really at the cutting edge in their space, to get started and get a kickstart and actually get their businesses running. But as I said before, of course, in the investment industry found ways to rort the situation, and unfortunately that caused some problems, which then reduced that 150% tax deduction down to 125%. Eventually, it became an unworkable tax incentive until more recently, when they came up with a new method, which they chose to have as more of an offset as opposed to a deduction. And you can see there on the slide, the two incentives there are a 43.5% refundable tax offset for eligible entities where their turnover is less than 20 million per annum. So we're focusing on the smaller corporations, the SMEs, and then a lesser tax offset for all other eligible entities. And these have undergone a little bit of change, and more recently under the 2020-2021 budget, they've tried to improve those circumstances and allow for lesser restrictions on how, in fact, that offset operates. but you can see that there are means and ways of trying to encourage industry to develop their technology as best they can and make use of those particular exemptions from the tax system. Okay, what they refer to as core activities, core research and development activities, need to be considered to be experimental activities. And this is where that risk element that I mentioned comes into fruition. There have to be an outcome that cannot be known or determined in advance of the basis of current knowledge, information or experience, that can only be determined by applying a systematic progression of work that is based on principles established in science and proceeds from hypothesis to experiment, observation and evaluation, and leads to logical conclusions. And so the purpose ultimately is for the production of new knowledge, and therefore things such as new and improved materials, products, devices, processes, and even services. In addition to that, they've also allowed for supporting R&D activities. So those that are directly related to the core research and development activities. However, if those activities produce or are directly related to producing goods or services, or are listed as an activity excluded from being a core research and development activity, then they must be undertaken for the dominant purpose of supporting core and research and development activities. So we're looking therefore at expenses that would be associated with the general running of a business, but you would be looking at only those expenses that are associated with the research and development side of the actual business. And so that those sorts of examples of trying to limit, I suppose, where the concessions are available, but by the same token encouraging that, of course, if they're associated with the research and development, then that in itself becomes the incentive. So then we saw in 2017, 2018, some very key incentives come into play from the venture capital side of things. So we have effectively an early stage investor in startups incentive that was basically looking at encouraging new investment in small Australian innovation companies. But looking at those companies that might have a high growth potential, and by doing so, encouraging investors by providing them with a tax offset and a modified capital gains tax treatment. So looking at, in other words, the capital that they might be gaining over time, how the taxation on that would be dealt with, to be, of course, at a more beneficial rate than would normally be the case if they invest in an industry that wasn't considered part of their startup regime. The other area is, of course, venture capital, and I mentioned beforehand, venture capital has not been strong in Australia, but is something which has been a focus. And so we're seeing the use of venture capital limited partnerships as investment vehicles, and providing through the tax system tax exemptions for those who happen to be investing in such innovative companies at the early and growth stages of a startup. Now that's all very well. Again, looking at the early stages of a business, then we have to think about the later commercialization side of things, and where the business is at a more advanced stage, shall we say. Now, some of the things to think about there is looking at this question of changes to the same business test. Now, this talks about where, for example, you started off as a small company and effectively you decided to start off. Remember, I mentioned at the beginning, you could be starting off as a sole trader or as in a partnership, and then you decide later on to form a company. Well, moving from the sole trader level to a company could be perceived as being simply selling of the business. But in actual fact, if all you're doing is changing your actual legal structure, then you are able to then avoid some of the tax events that take place with that process of buying and selling capital. So that usually what would happen is if you happen to sell your capital as an individual to another company, you'll be paying capital gains tax on the sale of that capital. But because it's yourself moving into a company, which is considered to be a separate legal entity, but you're the main shareholder of that company, then that is an exemption at that point in time until such time as you then sell your shares in that company on to someone else. So you're actually avoiding, by avoiding having a taxable event in that process. And that was for many years called the same business test. And it expected very much to be a situation where you're in the same sort of business before you form the company and after you form the company. But at the same time that you have roughly the same people involved before and after. And what's interesting about that is that they've changed the rules to this recently to make it a similar business test. So taking into account the fact that a business might actually change slightly in its nature from one to the next, and to that by doing so to not lose that benefit because you've slightly changed the business by growing in actual fact. And that's an important thing to keep in mind. Another way that the government can actually do something to assist that further development of the growth of a business from not just the R&D stage, but also in the actual commercialization stage. What we've seen in the budget in Australia came out recently this month, and we've actually seen some even more positive results come out of the current budget in an attempt to further encourage businesses who are engaged in R&D and production of forms of intellectual property. But in particular, there has been a concern, of course, that our life sciences industry hasn't been as strong as it could be. And so what the government has decided to do is to follow suit with what many other countries have been doing around the world, and that is include the incentive called the patent box. I'm sure you've probably heard of this before because India is one of the countries that already has a patent box, and we've only just adopted it this year. Well, actually, we've agreed to adopt it this year, but it doesn't start until July 1 of 2022. Now, the interesting thing about that is that the taxable income that is derived from the use of the patent, if it's an Australian patent, it would therefore attract a concessional tax rate on the actual income. Now, that's an interesting mechanism by which to encourage both ownership in Australia and potential commercialization in Australia. The details of how this particular patent box is going to operate has yet to be actually announced because the government said they were going to take into account, obviously, consultation with industry. They focused the concession on Australian medical and biotechnology patents. And the tax rate in this instance here will be reduced to 17%, which when you consider the corporate tax rate in Australia is generally 30%, unless you're an SME, in which case it's 25%. It is a significant reduction from our perspective. However, from a comparison worldwide, with patent box schemes having been around for quite some time now, we see that, in fact, it's not a particularly generous one by comparison to other nations. India itself has got an 11% concessional tax rate under its patent box, and compared to India's standard corporate tax rate of 30%, that's comparable to the Australian circumstance. So it's interesting that we are still significantly higher. Then you've got the United Kingdom, which has a 10% income tax rate, concessional tax rate for its patent box, rather than the 19% which applies to its corporate rate. The Netherlands, for example, has only a 7% concessional tax rate on its patent box compared to its 20 to 25% corporate tax rate. Poland, for example, has an even lesser one, a 5% concessional tax rate compared to its intellectual property regime, which for its intellectual property regime, when its standard corporate tax rate is much like the UK at 19%. So you can see that there's competition right around the world for trying to obviously encourage patents being produced within the jurisdictions, various jurisdictions, and trying to encourage that commercialization to take place in those jurisdictions. How successful these examples are, I haven't seen the figures at this point in time. It'll be interesting to hear from those of you here, those of you tonight who perhaps are familiar with the patent box in India, how successful it has been there. Professor Wilson, I don't know whether you have the similar situation in the United States, whether there's such a tax incentive in that instance there that you might be able to enlighten us on. But that is certainly one example that the current government in Australia has decided it would actually embark upon, even though some research that took place back in 2015 indicated that they didn't think it was going to be that particularly encouraging in the Australian circumstance. And I've also heard some very interesting commentary by the industry and by advisors to industry that unless you're focusing very much heavily on trying to get manufacturing taking place and actually focusing the incentives on the manufacturing side of things, it's not going to have that great an impact on developing industries within Australia from that point of view. So the last stage that I'll mention here, of course, is the disposal stage of the intellectual property. So when, for example, either the asset comes to its end or when the asset is being sold on to another entity, you need to think about what form does the intellectual property take? Is it a capital asset, which needs to be dealt with from one perspective? Is it a depreciating asset, like the patents and the designs, etc. we talked about beforehand? Or is it something like some form of trading stock? And that will be relevant to industries that are specifically actually R&D companies that do R&D for others, in which case their business is to produce IP. And you could classify the work that they do and the production of IP that they make is just another form of trading stock for them. From the capital gains tax perspective, where there is the on-selling of capital gains tax assets, in Australia we certainly have some special concessions for small to medium-sized enterprises, where the owners of those enterprises are given special tax concessions when, for example, they sell their business, provided they've had their business operating for 15 years or more. Or, for example, the smaller family-type businesses where the owners go into retirement and are able to get special concessions for the sale of those capital gains, capital assets. And then finally, the thing to think about also is when it comes to questions of your non-registrable forms of IP, such as know-how, confidential information and trade secrets, how they classified. Well, more often than not, they've been treated as ordinary, as part of generally providing of services, in which case the income derived from them tend to be classified more as ordinary income rather than as capital gains. Although we do have examples where the courts have perceived the sale of confidential information or trade secrets as a capital gain if what they're doing is selling the rights to that information once and for all. So these are some of the things that you need to think about from the point of view of commercialization, the different types of incentives that might be available from all the different stages of the life cycle of intellectual property rights, I'm going to stop there and happy to take any questions. So thank you very much for your time and looking forward to hearing from you.
Thank you very much, Madam, for your insightful theme address.